he was in the other courtroom.
The neighboring one.
For the record, I did provide a copy of all of those
Which, in my opinion, he should have stayed there. But that's up to the judge.
to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name. It is not me myself. I don't recognize it.
That's BS. That's BS. All right. Why did he recognize himself as Darrell Brooks upon initial capture? He identified himself as Darrell Brooks. So all he's doing is just literally lying. That's all it is, a lie.
Name, nor do I consent to being called
Dude,
by one
shut up, man. You sound dumb.
with all
Shut up.
respect, Your Honor.
You're a fool.
And we still have yet to address subject matter
No, we don't,
jurisdiction
because apparently
as
that doesn't matter.
on the record.
That doesn't matter given your custodial status over in Dodge. So shut up with that crap.
May I receive those original copies time stamped?
All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet.
Thank you for ignoring him. You know she knows he's a fool, just like everybody in America does.
I believe within the last year, the jury instruction on credibility of witnesses
The Bible says the dead know nothing, but I'm pretty sure they all know he's stupid, dumb as hell.
was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72.
So she's going over jury instructions,
It's the,
which
it adds a paragraph before the last paragraph that starts with "there is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys.
in my opinion, she's an excellent judge. I like how she operates her courtroom. She gets everything precise. Everything's precise. And that's important because the whole purpose behind that is she doesn't want anything to come back to bite her in the behind if he goes to the appellate court upon review of the case. That is solely the reason. Everything is so strategically done and carefully meticulously done on behalf of this judge. Somebody was telling me the other day, man, she deserves a year vacation as a result of her involvement trying to deal with this utter idiot. This idiot. I don't know how she did it, but kudos to her. I don't have the patience. I would have came off of that bench and put my foot. Woo! Let me calm down here.
And so I will just make that correction and make sure it's,
I accept the value in return for value of this document, and Your Honor, I requested that I have copies of my filings from earlier.
Them,
time stamped.
them filings don't mean nothing.
Mr. Brooks, I'll provide you with the copies
They don't mean
later on.
they
I
don't mean
can
a thing.
continue with the instructing of the jury and have the parties make their closing arguments.
So let me
No,
say this. Let me jump in real quick. Now, those filings that he talked about, is that pursuant to the? I'm just asking y'all that's watching. Is that those filings that he kept bringing up? Was that pursuant to the alleged exhibits that he was talking about? Because I ain't seen no exhibits that he had other than what the state had. And how could he have anything other than what the state has as it relates to the exhibits? Because that was a part of the discovery. And so it was denied when he talked about that he wanted to place things in evidence. What did he have? What did he have that the state did not already have in discovery? That's what I want to know, y'all. Please.
with
I
all
did,
respect, the state received copies. How come I can't receive the copies of my filings?
You need to receive a behind whooping.
you know what, I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the
He wants the
records.
original,
It
but
won't
that
be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour.
Well, you know what? She should have had a time limit on all the BS that he was spewing for 2 hours. Why wasn't there a time limit right there? But some people may interpret that and say, well, that could have been strategically done if, in fact, he tries to go to the Court of Appeals to try to suggest that he was unfairly treated in court. Because that 2 hours that he was given will debunk that false narrative if he tries that crap. Come on
Mr.
with it.
Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. And then you, as the opposing party, will have an
But wait a
opportunity.
minute, can I jump in? I don't even think that they had a burden of proof given the overwhelming evidence. What was so burdensome about it? There wasn't no burden to prove what he did. They did not have a burden with that. It was videotaped, Judge Dorrow. It was visual. We seen what he did.
Of proof, and that is provided with the
Wasn't no
excerpt
burden.
from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts.
Now you notice what she said. That was provided to him. That was provided to him. So he can't say that he didn't receive anything, given the fact that he kept on saying, I accept value and return value of these documents. So he can't say that he wasn't provided anything. There's a big difference between being provided and then not accepting it or returning what was provided. Come on with it.
Arguments focus the issues for the jury. I just talked about the order of the arguments.
The sequence.
The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And
He was talking nonsense for 2 hours. There should have been a time limit.
Mr. Brooks, I will advise you that I certainly will wait and
Look
see
at
how
you
you
get
present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on.
right.
As
The only thing that would be improper is him talking about jury nullification. That is a breach. That is violation. That is simply, and then for him to literally say that's what he was going to tell the jurors. That was triple, quadruple violation.
A clear indication from this court that what you are stating is not proper under the
It's improper.
various rules and case law that govern
Look,
closing
what is he
arguments.
looking at?
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
Now wait a minute. Now he says without prejudice. Listen, first of all, he'd already prejudiced his own case. Watch this, given the outcome, because where is he today? He already prejudiced his own case. He prosecuted his own case. Some might say an even better prosecutor than Suapa. You dumb fool.
All right, then with that, I will have the go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
I think Captain Dussault was the one that when Mr. Brooks went during the jury view, and this is something that I suggested, he should have been, because he wasn't going to be in the presence of the jury. The jury wasn't going to see his custodial status, but he had the right to be there. So Captain Dussault, he's over security. I think that they should have placed Mr. Brooks in a portable cell to view that vehicle. And why did he want to view it anyway? Why did he want to view it anyway? It wasn't like it was moving the needle in terms of his success. No, that was thwarting. It was thwarting his success, especially when the jury saw it. See, that's why he didn't want them to see it, because he knew that would thwart him having a chance to get out of this.
It be displayed.
Come on.
Put it, like right here, and then you want me standing at this table.
I do.
Yes, so I would just position it like right here.
Um,
And I don't have to leave it up through the whole thing. I realize it blocks the view of
Yeah, you ain't gotta have it up the whole thing.
people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as
Yeah, I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor, it's exhibit.
Oh, I love how they're ignoring him.
Are they exhibits? I'm confused to what they are.
Are you a
Mr. Brooks,
butthole?
I have a ruling. The state has made a request, I've granted it.
Yeah, but
In
I'm
terms
saying
of-
I don't understand what
It don't matter.
is being shown.
It don't matter. You decided to represent yourself. Whatever you don't understand, that is solely on you. Move on.
They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing
See?
argument.
So can I put up exhibits?
No,
Um,
because it's BS what he got. What he got is the opposite of what the state. I talked about this earlier. What he allegedly has, because I ain't seen nothing, is absolutely frivolous and outside of what the state would have that was already in discovery. So that's a violation right there, as indicated.
To put up
Mr. Brooks, I don't know what you have planned for your closing argument, so.
I'm making
BS.
the same request.
It's
May I be
BS.
able to put up
Well, I guess it
exhibits?
depends on what it is, sir. So I'm not gonna take up any more time, because what I intend to do is,
Exactly.
once the state goes through its closing, I may take just a short comfort break, depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously.
Yeah, but it's out. But wait a minute. Don't try to make the judge. No. Don't try to make the judge look stupid by saying obviously, because what you have is not a part of the discovery. So it's irrelevant. It's inadmissible. Gonna use the word, use such a word, obviously. Well, you are obviously stupid.
Yeah.
Thing, I may take just a short comfort break depending on
Fool.
how long it is. And if there's something in particular, what are you will
It's
need to tell
crap.
me what it is. As long as it's an exhibit from this case,
Right.
then I
It has
wouldn't
to
have an
be
issue
from
with it.
discovery.
They would be from this case, obviously.
Don't use that word obviously. Don't use
It's
it.
not nothing that the state has.
Then it's irrelevant
I'm
then.
not aware of exhibits that the state wouldn't
Would not
have
have.
that you would have.
Exactly. What the hell is he
Everything that's
talking
been received, we have a list.
about?
Um,
See how dumb he
so if
is?
it's not something that was received during this trial
Exactly.
as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or
Exactly.
appropriate for your closing.
Exactly. Exactly.
They're part of my filings that you filed.
The filings have no relevance to
Ex,
the
ex,
issues that are before the jury. The closing arguments are to direct the jury
no
so that they
relevance.
have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges.
See, here's the problem. All this is doing is indicating this is just showing how dumb he is, how ignorant he is, how much of a rank amateur attorney, so-called attorney he is. Because any attorney would know that, would know that. But this is just exposing him being a rank amateur. Has no clue what he's talking about, has no idea what he's doing. No different than somebody blind trying to drive your car or drive you somewhere. Ain't got a clue. And then you're gonna use the word obviously to try to to try to demean the judge's intelligence, and you just as dumb as they come. Boy, bye.
Like subject matter jurisdiction or uh, like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge
Of
of
the
the law.
law.
That's
I'm
why I
not
have all of these jury instructions to
Exactly.
give to the jury.
I'm not referring to subject matter
Shut up,
jurisdiction.
man.
What are you referring to then? Be very specific so I can make a finding and
I
ruling.
was specific
No, you ain't.
in my other filings.
What
That
filing,
was
Not
dummy?
specific enough,
my
sir. What are you
my
referring
court
to?
docket
Exactly.
sheet. Let me know when you're done.
No, no, no,
Which
no.
filing,
Be
sir?
specific.
Not generally, but specifically.
I like how she cuts him off.
Are you done?
Are you quit? Are you done being stupid? Are you done being dumb? How dare you?
Are you done?
Sir, that's very rude and
No, I
disrespectful.
didn't know if
Somebody
you
need
was
to
finna say
punch him in
something.
his
That's why I'm
face.
asking, are you done?
Which, what
Be
filing
Your Honor,
are
how
you
specific.
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that
Because you're not being specific. You're talking about filings. Which filings are you talking about? You got to narrow it down. She don't know exactly what you're talking about when you're being vague. You're being very I don't know. You come on, y'all know the vocabulary word. He's being unclear. Not specific means to be unclear. Ambiguous. That's what I was saying. There you go. Very ambiguous. Very vague.
it's not. I didn't know if you was gonna say something else.
Shut up, man,
I've
and
asked
just
a
get to the
question,
point.
sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which
Hey,
filing are you referring to?
specific answer.
All my filings,
That ain't specific enough.
my notice of appearance, my statement of particulars, my bond, the
What
court docket sheet,
what does that have to do in terms of placing things in evidence? What the hell? Y'all help me on this, y'all. What the hell is he talking
all of those filings.
The requested display those to the jury is denied. It's not relevant.
Exactly.
How's it not relevant? Not even your
Because it
oath
ain't
of
got.
office.
Determination, sir, so I am going to start this.
Not even your oath of office can be
Oh,
shown.
that is
No,
definitely
that is
irrelevant.
not relevant to these proceedings, sir.
It
That's
is.
definitely.
It's not
Shut up.
relevant in front of the jury.
So
Why?
wait a minute. So you mean to tell me her oath of office? Oh, excuse me. What the hell's going on with me? See, I'm so upset with him because he's pissing me off. Listen. So you mean to tell me her oath of office is on trial versus what he did at the parade? Really? Really? So her oath of office is more relevant than what he did at the parade. This man is. Ooh, I'm about to go off. I can't take this. I want to jump out of this chair and just, oh, y'all, pardon me.
Not relevant.
He's dumb.
Mr.
He's just
Brooks,
plain stupid.
Can you
you
explain
are
why that
not
shit
going
Shut
not
to
up.
be
relevant?
able to
Shut up.
raise those types of issues and present a closing argument based upon my oath of office, whether
That's
I'm licensed to
irrelevant.
practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of this
Right,
evidence.
for what he did. Stop trying to flip this. Stop trying to reciprocate and make this about her oath of office. What about what you did? There's 76 counts. There's 6 people dead. There's a plethora of people injured. How dare you demean and undermine that and make this about her oath of office? Oh
These
my
six
God.
charges that
The
have been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their
They
rights. They
ain't
should
got
know
nothing to
that at
do with what
least.
you did.
Mr. Brooks, I'm putting you on notice that if you continue with this
Bullshit. BS. That's what it
insistence
is.
on presenting information that's not properly before the jury
And
as
it's
evidence in this case, that I
forfeiture.
will instruct you during your closing argument to move on
I would have forfeit.
and
Let him.
potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation
And a
of court's
forfeiture.
direction
So
to
they
you.
can't even know that I got a shock device on my ankle.
Why would they care
They
about that?
absolutely do not need to know that,
Why
sir. It's
not?
not
It
relevant
don't
to the
matter.
determinations of guilt or innocence.
All right, so we're gonna do part 2 on this. I just wanted to shed light, particularly on a part, well, just a portion of this trial. But y'all see how dumb he sounds? Do y'all see how dumb? Y'all see how he tried to reciprocate and make this about her oath of office? Make this about a shock device on him? Make it seem he's the victim in this? Never mind the real victims, but let me pretend to be a victim. That is absolutely chaotic. This man is ominous and deserved exactly what he got as a result of those lengthy sentencing. That lengthy sentence. Y'all comment.